Welcome to IP Goes Pop, your source for exploring the interface between intellectual property and pop culture. The IP Goes Pop podcast series is created and produced by Volpe Koenig, an intellectual property law firm based in Philadelphia, Pennsylvania. Visit us at vklaw.com. This program should not be considered legal advice. Please consult an attorney for your specific situation. And now your hosts, intellectual property attorneys, Michael Snyder and Joseph Gushue.
Greetings and cheers, listeners. Welcome to IP Goes Pop. This is our first holiday special. The holiday, I guess there's no spoilers here. It's October, so the holiday is Halloween. Let me bring in co-host extraordinaire of all things popular culture, Joseph Gushue. Joe, hello.
Hello, Mike. Happy Halloween to you. This is one of my favorite holidays. I am so happy we brought Halloween to our podcast.
By the way, I have never before been part of one. Have you ever been part of a Spooktacular?
I have not.
Because this may be a Spooktacular. I'm not gonna say for sure. Let's see how it goes, but it has the makings of one.
Well, I think we have all the ingredients for a Spooktacular podcast, and I hope everyone's getting into the mood of the holidays. And we just did Trunk or Treat earlier this week, so we are Halloween has expanded from what was once a one-night event to a two-weekend event to now the better part of October event.
So I have, where I'm located, it's not a big Halloween decoration area right where I'm located, but one of my neighbors has the most spectacular Halloween arrangement. It's orchestrated to music, lights, there's smoke. It is, we every night we walk down the block and look at it. It's amazing. So I think it's going to be a big deal. And I love when people go all in on Halloween. I think it's a fun holiday. And by the way, I don't know if this is, if you found this as well, but once you tell people that it's one of your big holidays, you find that there are more and more people, this is their number one holiday.
Oh yeah, people will start talking about it.
But there's low expectations and there's great payoff. I think that's one of the Halloween.
I think so too.
I think that's why people love Halloween.
And who would have thought that there are this many intellectual property related items with Halloween?
Very surprising, really interesting, excellent. Boy, the segues. It's even a holiday segue. But just to set the table, let's just talk about a couple of the iconic franchises. I will admit, Joe, that I'm not a huge horror movie buff due to certain family members who it just not their thing. But let's hear, can you rank maybe the top three franchises, top four, top five?
Well, yeah, I mean, it's tough. In recent years, the Saw franchise jumps out as a Halloween franchise that probably many people are familiar because they released a movie basically every Halloween for 7 or 8 years running. And Halloween movies are one of the most profitable movies that a studio releases, spend very little budget on them. And people are always looking for October comes around, scary movies, they sell tickets. People are going out to see these movies. So Saw jumps out, and then there's Halloween, Friday the 13th, and then the Scream. There are a couple ones of those. So like every so often they're able to, an idea hits, and like most movies anymore with franchises, they will wring every potential idea out of a lot of these Halloween related ideas. And then all these iconic horror villains from these movies then started fighting each other and teaming up. So
there is like the Marvel Cinematic Universe and the monster. I guess there is kind of a horror cinematic universe. I don't know the ins and outs of which characters share the universes, though.
I don't know either, but I do know Universal. I think you've been to their theme park a number of times, but they own some of these horror characters too. Even though they're in the public domain, they've made movies about them. And Van Helsing had a movie that they sort of had. So Universal, I believe, owns some movie rights to some of these characters. They put their spin on a character enough to make it relevant and newer to them. They've added some creativity to some of these characters that are just in the public domain, which we've mentioned as a term before, like mummies werewolves, and a Frankenstein-like creature. So some of these themes you'll see in a number of different movies, but even that, there was a monster universe at some point that was trying to get launched. I think it was a very a rough start to that.
I know. I recall that as well, because I know that I forget what it's called, the Godzilla and King Kong universe, which really is going gangbusters. I mean, that really got started, in an explosive way. But that has a universe. And I know that there's Freddie versus Jason is at least one of the horror movies. And I know that there's Jason in space, maybe. So they really do. Those characters tend to get around.
Oh yeah, you'll find them like even Leatherface, from the Texas Chainsaw Massacre franchise. That's been relaunched a number of times. He's popping up in different movies. So as pop culture fans, a lot of these villains and horror movie, monsters are very familiar to a lot of people, and you're seeing them everywhere, especially around October.
And I think that one thing some research I did for this particular episode, I wanted to find out who was the person or where was the board meeting at some candy company where they came up with fun-sized, meaning a smaller version of a full-size candy bar, and the kind of 1984 doublespeak that there's nothing fun about a smaller candy bar.
No, I guess they couldn't sell it as something worse. They had to put a spin on, why am I getting like 5 Mike and Ikes in this bag? This is crazy.
Right. Like, isn't this fun? You have so much less.
No, I have to open up like 10 of these packs in order to feel like I ate something. There's nothing fun about this.
Well, I'll tell you, it is a good feeling handing out a full-size candy bar when it hits that bag.
Oh yeah. Then you got all the kids running to your house too, though, because word gets around that you're the person giving out the full-size candy bars, and you're a very popular house then.
So one Halloween war story, then on to the cases. We had just moved, and we didn't know what the influx of Halloween trick-or-treaters would be like in our new location. So we were totally unprepared. We didn't think it didn't look like a highly traveled area. So the kids just started coming in droves, and I'm grabbing my daughter's school snacks and just handing those out. I'm wondering if I'm going to have to just like put cereal in Ziploc bags and hand those out, or just money,
Whatever you can get your hands on. You're like, I cannot turn the light off of my house. These kids are going to be very mad at me. I need to just keep giving them stuff. Then there's those years where probably the next year you buy enough candy for many neighborhoods and no one comes by. And then you're sitting on this huge supply of candy,
which you have to, eventually turn to.
Always. You got to get that stuff out of the house. It's 1 week later. It's like, we got to get rid of this candy. This is going to be a problem.
And I did see, I like to see when people have a basket out and it's a little sign, take one and honor system. And when that works, that's a nice thing to see. So there is a spirit of Halloween, I guess, not just the tricks and treats. So speaking of the Halloween franchise,
another segue,
harsh segue. I hope anyone listening to the podcast didn't hurt themselves. So this is actually a case from Eastern District of Pennsylvania, right out of our hometown in 2000. So it's a recent case, and it's about the Michael Myers mask from the movie Halloween and a battle over that mask. And the mask has a fantastic history. If people don't know it, Joe, can you take us through the facts, some of the facts of the case?
Sure. Yeah. This is, you can impress all your friends with this bit of Halloween trivia, but the mask worn by Michael Myers in Halloween was based on a mask created and designed for Star Trek, and it's supposed to be Captain Kirk. It's supposed to be his face, and they made some modifications to it for the movie Halloween. So when John Carpenter is getting his team together to make the movie, and they want to put a creepy mask on the villain of the movie, they turned to Don Post, and he had been in costume design, and he designed a mask worn by Captain Kirk that was a cast of William Shatner's face.
So just to stop here for a minute, a couple of things. I know Don Post is kind of the king of Halloween masks too, those latex masks when you go into a Halloween Adventure or Spirit Halloween, the pop-up stores. So he was definitely someone you could expect to be involved if you're turning to, a reputation for someone who could create a mask that you need for a horror movie, but also the fact that it's William Shatner, and if you look at it closely, you're like, oh yeah, it's William Shatner. So I know that years later, people have told William Shatner, who can be kind of a depending on the interview, kind of a thorny interview. I know he was also a kudos to a 90-year-old astronaut, William Shatner, amazing. He finally made it, and but he was so surprised by it and made them tell him the whole story of the mask. But at any rate, so all right, so back to the story. So they get this William Shatner modified mask.
They get the mask, they put it on Mike Myers in the movie Halloween, and they pay Don Post for his work $150. And the movie comes out, it becomes a sensation. Everyone's seen Halloween. They very much associate this mask with Halloween and Mike Myers. And then Don has the idea of selling another mask, and he's calling it Don Post the Mask. And that's based on the Shatner mold that he had. And he started marketing it as if it had a connection to the film.
Now, first of all, Joe, sorry to interrupt, but this timeline gets really weird. As far as, what was the first mask? What was the second mask? What was the Don Post mask or Don Post the mask? First, there's William Shatner's mold face. Then it is modified by Don Post for the John Carpenter Halloween movie. Then later, he also wants to sell his version, thinking that he's the original creator. And he again copies the Shatner mask, but it also looks like now the Halloween mask, if you will.
Yes, it's sort of a copy of a copy of a copy. We have different timeline because Halloween came out in 1978, and then it was a little bit before the tradition of trick-or-treating and Halloween became really, really big in more commercialized terms anyway, bringing some of the, pop culture themes into it in like the mid 80s. And that's when this Don created his mask version. And then it took then a little bit later, almost till 1997. So Don's been selling his Don Post the Mask, which is basically a very similar to the Halloween mask, which was in the actual film. And in 1997, he filed for a copyright registration for Don Post the Mask.
Now here's where things started to go a little bit bad for the Don Post studio group, because there was an issue with the copyright that they were filing. So when you fill out a copyright form, which is not particularly complicated, and there's different fields that you fill in. Copyright, we talked about before, they make it a little bit easier for creators. It's a little bit easier than trademark, to fill out the form. And there's a lot of directions. And actually, the Copyright Office has a lot of circulars that are very helpful. There are technical aspects to it. Parts can get really complicated, which I think will lead to a next case that we talk about. But here, they didn't properly identify the work that it was based on. Is that right?
Yes, that's right. And that sort of comes along with when you're applying for the copyright here, it's a derivative work. So Don Post the mask was derivative of the Shatner mask with a modified facial expression. So based on that small change, the patent office denied this particular application. So then what he did then was submit another application, another copyright application, and left out the part that the mask was based on the one used in Star Trek for Captain Kirk, and instead claimed that it was an original creation. And that was the copyright that was granted.
So by leaving off the identification of the work it was based on, that is really where the copyright application kind of became invalid.
That's right. When Don Post Studios took their copyright application and attempted to prevent another company from actually selling merchandise based on the Mike Myers Halloween mask, that's what brought us to this case. And that's where the ultimate judgment of things wound up working against Don Post the Mask and the Don Post Studios?
Well, there are some clear lessons here, some of which are to ensure that your work is the original work, also to ensure that there are technical issues, and even though it might seem simple and straightforward, be careful and make sure that you're truthful when you're filling out these forms. This is a government form. I mean, the Copyright Office is a government institution. It has certain questions on it, and to have a valid copyright, you have to provide valid information. So I think the court here was not happy about the failed first application and then leaving off information in the second application.
Yeah, this will always come out, especially in litigation. You need to be very careful about making accurate and complete statements to the patent office because, again, you want to make sure everything's about almost fairness and being above board with your admissions here. So by leaving out some critical details in things, and also, I guess, attempting to use some intellectual property laws in a way they weren't necessarily intended to. Don Post Studios didn't get the outcome that they hoped for with this.
And I think it got even more complicated because I think that the Don Post Studios had to try to show that their mask in the copyright registration, many years later was more like the original Shatner mask, but not like the intervening Halloween mask. I mean, it got very complicated factually.
Very technical, yeah. So I guess even the mask that Don Post was selling as Don Post the Mask, it was originally a different color than the Halloween mask, the white mask that we're all familiar with that. And then later into production, it was changed to the white color also. So he was definitely moving this separate mask, which was another mold in the this spooky face, a spooky mold of a face mask, closer to the Halloween mask that he originally created, which was very commercially successful this way.
Well, by the way, another thing that's interesting, when you said it's like a spooky mask or scary mask, these masks become, these characters, like you said, they become so much part of pop culture that they kind of lose the scary part and become these characters that are kind of beloved characters. And you see a lot of really good memes, and maybe I could link to one in the show notes about Michael Myers doing different things, hanging out with kids, having fun at Disneyland. So people actually root for them, I think.
Oh yeah, I think, and a lot of horror movie fans, I think they actually do root for the villains, like in the Mike Myers Halloween mask, or the hockey mask, or the Scream mask. So all sorts of different masks, very much associated with this holiday.
So the next case is a Friday the 13th case. This case has to do with the author of a particular screenplay, which, I believe ended up being the screenplay that Friday the 13th, the first movie, was based on. So, Joe, can you walk us through a little bit of the facts of this case? And it's again, this will involve some technical areas, but it turned out a lot different for the plaintiff in this case than in the Halloween case.
Yeah, so we've brought up a couple of these terms before in our podcast, but here, Victor Miller was hired by Cunningham Films to write the screenplay for this film project, Friday the 13th. And Miller and Cunningham Films entered into an agreement by the collective bargaining agreement between the Writers Guild of America. And here, Victor Miller, the author, wrote this screenplay as a work for hire. And Miller got a writing credit, and Cunningham Films, who he wrote this for, assigned the rights to the film and screenplay to another organization called Georgetown, who registered copyrights to the film. And in that registered copyright, they described this work as a work for hire. Then all of the associated rights to Friday the 13th film was then sold from Georgetown to Horror Incorporated. This is all done starting in 1979 when Victor Miller was first hired to write this film.
Right. So he was hired, but What this case then turns on is a concept which people, I guess, they throw around a lot. And you and I talked, I don't know if we talked about it in the Urban Legends episode, but we have talked about the phrase work made for hire. So again, we're in a situation, incredibly successful franchise. Years later, what happens? It's based on work made for hire. What happens next?
So we're going to fast forward to 2016, and Victor Miller believes he's not receiving appropriate payments for his work.
And by the way, what were the payment ranges in this case? He was originally paid about $10,000 for the screenplay and received some residuals, which, according to the case, were around $250,000 compared to the $60 million box office for the film.
Mm-hmm. Yeah. So in most of these cases, they're coming about by one party contributed something, was paid a certain amount of money, and then realizes that that wasn't a good deal based on how successful their idea was. So they're looking for ways to perhaps get a little bit more compensation. So in order to do that, he filed to reclaim his copyright ownership of the film using his termination rights pursuant to the Copyright Act.
Right, which is, just to sum up, so between the 35th and 40th year after an assignment, the original author can try to terminate and reclaim their rights. And that's what this author was doing. However, that only applies if it is not a work made for hire. So it does not apply if it is a work made for hire. So employees can't come back and do this, basically.
Correct. Yeah. So the outcome of this case turned on whether Miller was an employee or an independent contractor when he wrote the screenplay, because these works for hire made by employees during the course of employment are not eligible for this right of termination.
And I think when people, you see it a lot in, let's say, software. So a software company will hire a software developer and they'll say, oh, I have a work made for hire agreement. Well, that person's not an employee. There's an outside contractor. So even if you call your agreement work made for hire, you better have some assignment language, and you should also understand this potential termination right as well.
Yep. So basically here, Horror Incorporated, who currently had the rights to Friday the 13th, argued that Victor Miller, the author, created this on a work for hire basis and would not be able to take advantage of the termination rights. The Horror Inc. presented evidence, including terms given on the screenplay, in an interview of Miller where he said that Cunningham and Georgetown were the owners of the franchise, and the copyright registration form listed him as a work for hire. And then in ordering, Miller wanted to then present arguments that he was an independent contractor. So he stated that he should own the rights to the iconic villain Jason Voorhees as part of his copyright reclamation. And it was complicated because the image of Jason wearing the hockey mask didn't appear until part 2 of Friday the 13th. And Miller's draft contained not only Jason Voorhees as a boy, but also Camp Crystal Lake and Pamela Voorhees and other important pieces in this whole story.
So he really set the groundwork for all of the sequels.
Yes. Yeah, he planned this whole out in the first Friday the 13th, and then they subsequently make, I don't even know how many movies are in that particular franchise.
yeah, I'm not going to.
There's a bunch of them, and strangely, I've only seen Friday the 13th once a very, very long time ago. Not really fresh up, but I do know Camp Crystal Lake because I played Friday the 13th, the video game on the NES, way more times than I saw any movie related to this.
But Joe, this is why you are the star of this podcast, really, when we come down to it, because you are playing the video games on top of knowing the movies and the characters. And that's what we need here.
Oh, it was the worst. You would go cabin to cabin and you'd look for camp counselors, and then every once in a while you'd run into Jason in him, and it was it scared you so much because he just crept up.
Jump scare.
Yes, all the time. Yeah, as a young child playing. I don't even know how my parents bought me Friday the 13th, the NES video game, but the 80s were crazy that way.
Not just that way.
Yeah. So the question was really whether Miller, the author of this, should own the name Jason Voorhees and therefore the iconic mask that goes with it, or would they have to change the sort of the later parts about Jason, which is in part 2 and later, whether that's someone else. So this was the question that the courts had to consider in this particular case. And it was affirmed on appeal just recently, a little earlier this month, that Friday the 13th belongs to Victor Miller, the author.
I mean, this is unbelievable. First of all, they must have known we were going to do a Halloween special, because this is the decision's dated September 30th, 2021. This is very fresh law and may change the course of copyright law and analysis of work made for hire going forward, because this is out of the Second Circuit, which includes New York. And most of the courts look to the Second Circuit for copyright law. And, basically how goes the Second Circuit goes copyright law. So they give a very detailed, and I'm not urging anyone to read it. It is very complicated, and they go very deep on assessing the factors that are considered to determine whether a work is a work made for hire. And they look at all different things, including, the materials that are involved, whether the employer is paying taxes for the person, whether they're supplying a place for them to work, any benefits. So there's a combination of numerous factors they look at to determine and say, okay, are you an independent contractor who's just been hired as kind of a one-off, kind of a hired gun situation? Or the way you were hired, should you be looked at as an employee? And if so, the work made for hire doctrine will apply. It's not a new doctrine, but it is still evolving up to September of 2021, which is pretty fascinating in the world of law, because as you can imagine, there have been fights over whether a work is a work made for hire or not, because look at how much damages turn on whether it is in fact a work made for hire. So people will rely on this case for the test of work made for hire going forward.
Yeah, and then the different rights available to someone if it is determined not to be a work made for hire. So this brand new decision, we're going to be looking at it in a number of other cases, but as a result now, the court, it talked about Friday the 13th, who it belongs to, but it didn't really specify the scope of what rights of Jason Voorhees were giving to Victor Miller, the author of Friday the 13th. So now it's a bit uncertain where we'll see Jason next, or who owns Jason. So he may not be in the movie for a little bit. Jason's in limbo because no one knows who has the rights to.
So now it'll jump out. Look, it's Jason's cousin.
It's another member of the Voorhees family. We're gonna just we'll change that up a little bit. That's probably why Jason's mom appeared so much.
It's Phil Voorhees from the country. Yeah,
we're from Europe. He speaks with an accent. He's from overseas. We'll see him.
Actually, this is good stuff. So maybe we should take that offline. I kind of like where that story's going. But interesting to think about the era that is up, 35 years ago, mid-1980s. That's the era when some of these termination rights are coming up. And Joe, as you and I have talked about before, there's a lot of rebooting, reimagining, recycling. A lot of it is from the 80s. There are a lot of characters and stories, and let's say they're looking to reboot The Breakfast Club, or let's say they're looking to reboot other 1980s franchise.
Mike, how about this? How about our next segue, the Ghostbusters franchise, which is being rebooted?
which I actually saw the trailer for, rewatched it today in preparation of the podcast. So yes, so let's say, there's an author or some screenwriter who's like, let me pull out my files and look at my contract again. Or, I was kind of hired as a one-off, and maybe I have this termination right. Maybe I'm in the window to terminate it. So there's a lot at stake in the returning of the rights and this ability. It would be one thing if Hollywood was cranking out all new material all the time, but the fact of these reboots, which does, again, segue perfectly into this Ghostbuster situation, the fact that everything old is new again, and they keep using the same, or they sometimes keep using the same tried and true characters, really will benefit these authors and creators who were not employees or don't have an airtight contract.
Yeah, so this last case was pretty interesting in that Harvey Comics sued Columbia Pictures with copyright and trademark allegations, claiming that the very famous Ghostbusters logo that I think everyone can put in their heads really quickly. We'll put it in the show notes, a link. They sued for copyright trademark allegations, claiming that the Ghostbusters logo from the film by Columbia infringed on copyrights surrounding Casper the Friendly Ghost. And more specifically, and I did remember these guys' names, Laszlo, Fusso, and Fatso, the ghostly trio who were the enemies of Casper. Casper being friendly, these guys not being very friendly.
What cartoon house was Casper? I know it was the same as Richie Rich.
Richie Rich, yes, because Casper, it looks like dead Richie Rich.
Who pointed that out? Was that Bart or Lisa Simpson?
I think that is from The Simpsons. Yes.
So I mean, once you see it, by the way, you can never unsee it.
Yeah, that's the Richie Rich Afterlife universe with Casper.
But whatever cartoon house that is, I mean, I hate to. Well, those aren't great names. Let me put it that way. Of the ghosts.
No. I think those would not be named that if being named today. So that ghostly trio, they were the foil to Casper, and they appeared from time to time going back to the 1950s. And the copyrights on their work from the 50s were not renewed.
One thing for the listener, prior to 1978, copyrights did have to be periodically renewed or they would fall into the public domain. That is no longer the case. Copyrights last for the full extent of copyright of the term of copyrights and do not have to be renewed. So this is a case that shows you it really depends on when you bring a lawsuit or what era you're in, because there could be totally different rules of intellectual property law. So I just want to say that.
Let's just focus. Harvey brought suit claiming the Ghostbuster logo infringed on copyright trademark rights it held with Casper's line of comic books. And in particular was this character Fatso.
So if you look at it from, a 10,000 foot level, he's Ghost Lee. So it's kind of a sheet look of a body with a point on the top of the head, which I think is very distinctive. And of course, the Ghostbusters logo has that same feature. I know that the ghostly trio ghosts were a little bit angrier and kind of meaner and up to no good, where the Ghostbusters ghost is either surprised that he's being captured or somewhat friendly, which is on top of all this, the Ghostbuster ghost is not in Ghostbusters.
Correct. It's just the logo. Yeah. It's like a white version of Slimer that is a little different, but he has the pointy hat and he's just a heavier ghost. And as you'd imagine, Fatso the Ghost is also a little bit on the heavier side.
Oh, but you know what? I do have to say, speaking of reboots, in the reboot with Kristen Wiig and Melissa McCarthy, there was a creature at the end who did look like that ghost.
Oh, okay. The X'd out Ghostbuster ghost?
It was just the giant creature at the end. It's Ghostbusters. You have to have a giant creature at the end. But also, Boogie Woogie of Nightmare Before Christmas, I would argue, is a direct descendant of the ghostly trio, too.
I agree. So basically, there's a fight over the Ghostbuster ghosts going back to the ghosts from Casper, and focus a little bit on the trademark claim. Harvey, who's the Casper side, said that due to the similarities between these ghosts, Ghostbusters logo infringed on its registered trademark for the ghostly trio. And they argued that these similarities would likely result in consumer confusion, which is one of the tests of when you're talking about trademarks here. And Columbia, in order to counter this argument, said that a visual comparison of the two shows they're utterly dissimilar, and further that Harvey bears the burden of providing evidence of actual customer confusion. So it's pretty interesting when you look at these two pictures, which we'll put links into our show notes, but the court agreed with Columbia here, saying that the logos are largely dissimilar and noted some of the differences. It was, again, we're talking about the ghostly trio. The Ghostbusters logo ghost is one ghost, and there are three ghosts in the ghostly trio. And that's a pretty solid argument. And the red prohibition mark on Columbia's logo was a difference. And also the expressions on the ghosts differ. the surprise ghost, like Mike said on the Ghostbusters logo, is quite different than Fatso in the Ghostly Trio, who is not really surprised. He's more mean to Casper all the time and looking for ways to make Casper's existence, I was going to say life, but Casper is not alive. When talking about ghosts, I don't think you can use that term. Maybe offensive.
Great self-edit.
But that was some of the differences raised, and the court agreed that Harvey, in addition to failing to rebut that, did not provide the evidence of actual customer confusion here in this case. Again, I think the 1 ghost versus 3 ghosts was a pretty big difference.
I think so too. I think that there were more differences than similarities, which on any copyright case, it's going to turn to a finding of no likelihood of confusion once you find more differences, or if you can find more differences than similarities. So, wow, 3 really right in our wheelhouse Halloween cases. I think that's all we have time for in this pocket, but this is our first holiday special. I hope there's more to come. I don't know if Thanksgiving lends itself as well to the intellectual property world. I just don't know if there's that much. I know people love Thanksgiving because eating as much as you can, being a core to the holiday, and watching football, but I don't think there's that much IP around Thanksgiving as there is around some of the other holidays. But we will be back with other holiday specials, I hope. Joe, any last thoughts or any general last thoughts on Halloween?
Well, it's a great holiday. I hope everyone has a great time, gets in the spirit of the year, and hope you don't eat too much candy, and everyone can finish the year on a high note, going, not gaining all those holiday pounds that we usually do these next 2 months.
That's a different podcast. But for now, let me say, things that go bump in the night, perhaps it could be an idea that you have. Boy, tough to tie that one in. I tried the best I could. I will say, have a great Halloween. I hope you get non-fun size, perhaps even king-sized or movie-sized candy this Halloween. Thanks for joining us. Until then, we'll see you next time on IP Goes Pop.
The IP Goes Pop podcast series is created and produced by Volpe Koenig, an intellectual property law firm based in Philadelphia, Pennsylvania. Visit us at vklaw.com.